Thank you. State, you want to finish up?
Yes, Judge.
All right.
Good afternoon. First, I'd like to thank you for your attention and patience over the last couple of days. I know it's been a long day and a long time, but sometimes there was some tedious testimony that you heard. So thank you, everybody who appreciates that. So I'm going to try not to repeat a lot of what Mr. Segravia already went through. So I'm going to try to respond to some stuff Mr. Bureau said and then sit down probably fairly quickly. So I want to talk about premeditation first. So one of the things Mr. Bureau told you was that the defendant went to Walmart and bought milk and cat food and came home and there was another episode of harassment. And that was supposed to be proof of why this was not premeditated. So I'd like to talk about the harassment first. When Mr. Qiu got home that day, there was no harassment. That did not happen. Now, Mr. Qiu testified that it did, but you also heard from Nikita Cox. Ms. Cox was there in the house that morning with Mr. Tudor. The defendant was not. She was there in the house. She testified under oath that they were sitting there studying. Mr. Tudor was sitting at his computer desk, and Ms. Cox was sitting at another computer desk that was right next to it. They were being quiet, they were working on their computers. There was no harassment. That did not happen. The cat food and the milk, that wasn't for the defendant, that was for cats. That was for cats that were going to be at the house after the defendant killed his neighbor and went home and killed himself. That is not evidence of no premeditation. Now, Mr. Segravia spent some time talking about events that happened prior to the shooting for proof of premeditation. He talked to you about the journal entries from 2017, which is, again, prior to 2018 when this occurred, where the defendant said there will be a murder-suicide. He talked about notarizing the will. He talked about going and buying an extra magazine, or at least attempting to buy an extra magazine. He talked about loading up all the guns and the magazines and taking them next door. But for just a minute, let's ignore all of that. Let's talk about only what you see on the video. On the video, at roughly 12 minutes and 12 o'clock, 19 minutes, you're going to see the defendant walk from his house to Mr. Tudor's house. He's going to go inside the house. When he's inside the house, you can't see what's happening, but we know what happened inside. He went inside and he shot Edward Tudor. He shot him in the arm. You know that because you can see on the video when he comes out, he's holding his arm. You know it because the defendant told you that's what happened. That's not in dispute. So that's going to occur somewhere around the 12:19, 12:20 mark on the video. Then the defendant told you he went upstairs, he looked around the house, and then he went back outside after Mr. Tudor. He went back out there after him because he wanted to kill him. So then you're going to see Mr. Tudor go around the side of the house. He comes back to the front of the house and he ends up on his knees with his hands up. This is going to be at approximately 12:21 on the video. At this point, we've had 2 minutes. 2 minutes has passed since the defendant walked over there. That is plenty of time to reflect about your decision. While Mr. Tudor is kneeling on the ground, the defendant is trying to get him to turn his head so he can shoot him in the back of the head. That's what the defendant told you he was doing. That's what he told the detectives he was doing. That is premeditation. That alone gets you to premeditation. He then testifies that he shot him again. And he shot him because the first shot didn't kill him, and he wanted him to die. So he shot him twice in the abdomen, and then he shot him in the head. Now you heard from the medical examiner, the shot to the arm would not have killed him. That would not have accomplished the defendant's goal that day. If he'd shot him that one time and left, Mr. Tudor would still be alive. Then he shot him in the abdomen. First shot wouldn't have killed him either. He would have needed medical treatment, but he wouldn't have died. Then Mr. Qiu shot him again. That one was a fatal shot. Punctured his lung, punctured his heart, and medical examiner told you he would not have survived that. And just to be sure, the defendant, who's had ample opportunity since the first gunshot, shoots him in the back of the head one more time to make certain that he's dead. Now, I tried to write this down. I can't write quite as fast as the court reporter, so I believe this is word for word, but if it's not, please rely on your memory, not my memory. But when the defendant was testifying, Mr. Saradia said, so you purposely made sure to shoot Lee in the back of the head? And the defendant said, yes. Then Mr. Saradia said, and you knew that would kill him? And the defendant said, yes. Then Mr. Saradia said, and you meant to shoot him and leave him dead in the yard? And the defendant said, yes. He purposely did it. The defendant agrees. It was on purpose. This was not an accident. It was not misfortune. The defendant took the stand, under oath, swore to you, I did it on purpose. Then he went so far as to say, I meant to do it. I meant to shoot him in the head and leave him dead in the yard. Sworn testimony from the defendant in this case. That is premeditation. You don't even need to consider the year and a half of planning that went into this that he told you happened. You heard that he told Detective Gacy that he'd been planning it for a year and a half. You heard from the witness stand that he wrote in the journal in 2017 he was talking about it. You heard that on the day of the shooting he talked to Sergeant Bookaloo and told him he'd been planning this, I believe the words were, for a long while. You don't even need to consider that. The video alone gets you premeditation. Now, there was a little bit of talk earlier about the lesser included crimes. I'd like to touch on that for just a second, because you're going to get a verdict form. Your Honor, may I retrieve the verdict?
You may.
Thank you. You're going to get a verdict form that's going to have a few different options for you. And I know you haven't seen it yet, so the first box, the defendant is guilty of murder in the first degree as charged in the indictment. The second box, the defendant is guilty of murder in the second degree as a lesser. Third box, the defendant is guilty of manslaughter as a lesser. The fourth box is the defendant is not guilty. Now, as the jury, the judge is going to tell you that your job is to find the defendant guilty of the highest offense that has been proven, which is going to be murder in the first degree. That means on box number 1, you will mark that. You will not mark box number 2, you don't mark box number 3, and you don't mark box number 4. You only mark the highest charge that was proven. And there's one part that Mr. Saradia said a little bit confusing, and the jury instructions are a little bit confusing, but in reality, what you're being asked to do is not confusing. So, if you find the defendant guilty of murder, you then have to find if he discharged a firearm during the commission of the crime. And if you find him guilty of murder, in this case, the only way that you could find him guilty of murder is if you find that he discharged a firearm, because that is how the victim died. So you're going to get some instructions that basically say, if this answer is yes, well, if this is guilty, this needs to be yes. If that's no, this needs to be not guilty. Just because logically it would not make sense that he's guilty of murder, but he didn't use the gun. So that's the only part of it that's even the slightest bit confusing. But just can't do one and not the other. So the lessers, just in general how that works, is there are some crimes that if you commit this crime, you can't commit this crime without first committing this crime. So probably the easiest example would be, let's say somebody steals $10,000. You can't steal $10,000 if you first didn't steal $1,000. So if you're guilty of stealing $10,000, you're also guilty of stealing $1,000. But you would find the person guilty of stealing $10,000. Now, another thing that Mr. Pure talked to you about was Mr. Tudor bullying the defendant. Now, Mr. Pure told you that the only evidence was from the defendant, that he was being bullied. But I'd like to remind you that's not the only evidence you heard about this. You heard from Brian Smith. Brian Smith is the gentleman who testified first thing this morning, And he told you that he lived with the victim of this crime, Mr. Tudor, for roughly 8 years. He told you that he lived next door to the defendant for roughly 4 years. And he told you that when he was there, he never saw anything like that. He never saw bullying, he never heard yelling, he never heard threats, he never heard screaming, nothing. He told you that Mr. Tudor was nice to the defendant. He told you that when the power was out, he offered him his generator. That is in direct conflict to the fact that the defendant says he was being bullied. You also heard from Akita Cox. I'm not going to rehash that, but she told you that morning that there was no bullying that happened. Now, I'm telling you that because I want you to understand what actually happened. Mr. Tudor was not bullying Mr. Lee, or was not bullying the defendant. However, even if he had been, the defendant doesn't get to shoot Mr. Lee, Mr. Tudor. That's just not the way it works. He wasn't bullying him, but even if he were, it's completely irrelevant as to what the verdict in this case should be. Now, Mr. Pure also spoke about how it's a difficult time in the country, and we are a divided country, and he spoke about it somewhat eloquently and fairly well. And I can't dispute any of that. However, this is something everyone can agree on. The defendant is guilty of first-degree murder here. He said that in Mr. Key's mind, he had no other choice. And he talked about Mr. Key's truth. Mr. Key's truth is irrelevant when it comes to heat of passion. Heat of passion is reasonable person. That is what the judge is going to tell you. Not what did Mr. Key believe, what would a reasonable person believe? A reasonable person would not believe there was sudden provocation. A reasonable person would not walk next door, walk into his neighbor's house, and shoot him. Now, heat of passion is something that we clearly don't have in this case. Now, the first thing that Mr. Pure talked about with you was the Constitution. And again, he spoke about the Constitution very well, and I believe I agree with every single thing he said. And we're confident that you will do everything that Mr. Pure asked you to do. Give us a verdict based on the law, not based on prejudice, not based on emotion, not based on the defendant's accent. We are confident you will do that. The judge is going to tell you that for over 200 years, juries just like you have been able to sit in positions just like you are and reach verdicts in this case. The juries for the last 200 years have not had the overwhelming evidence you have in this case. In this particular case, you're fortunate enough to have actual video surveillance of the crime occurring. 200 years ago, that didn't exist. Juries were still able to do their job. You have the pleasure of knowing that the projectile fired from the gun, the projectile that struck Mr. Tudor is in fact the one that was fired from the gun that you saw in evidence. 200 years ago, that wasn't possible. Juries didn't get to hear evidence like that. You got to see photos, a lot of photos of the crime scene. You got to see pictures of all the drops of blood. You got to see photographs of the magazines. You got to see tons of pictures, maybe more than you wanted to see. That is something, though, that juries have not had for the last 200 years. You have all of this. You have recordings of the defendant admitting he did it. You have recordings of the defendant saying he planned it out. He used the word plan. When he was asked on direct examination by Mr. Pura, what does premeditated mean? He said it means to plan. When he talked to the police, he said he planned. He wrote about a plan in his journal. This is premeditated murder. So, when you go back to make your decision, please keep in mind all the evidence that you heard. If you'd like to review it, you can. You'll have the opportunity to watch the video television again if you choose to do so. You'll also have the audio recording that you heard. If you'd like to listen to it, you can. Take your time, review any evidence you need to, and make your decision. And the only proper decision here, the only proper decision that will honor the oath that you all took on Monday when you were sworn in as jurors, is to find the defendant guilty as charged.